I want to thank the sponsor of today's video, and that's Arms Directory. Arms Directory is the only two-way protected social network and marketplace. You can post your favorite pics, you can talk about acquiring things and local events in the area, and also post videos of your favorite upgrades. I want to thank them for being the sponsor of this video. You can check them out at armsdirectory. You know what.
Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. On this channel, I have chronicled the New York State Rifle and Pistol Association versus Bruen decision that was handed down by the United States Supreme Court, where Justice Clarence Thomas basically did a huge correction on gun control, brought everything back to the founding, and to sum it up, he said that the only test going forward for whether a gun restriction law, etc., passes muster for the Constitution is if it can pass the text, history, and tradition test. If it is not in the plain text of the Second Amendment, then it must be in this nation's history and tradition of gun control in and around the time the Second Amendment was adopted, 1791. And we've seen, and I even did a video on it, I'll have it floating above, many cases already where many laws have been overturned or deemed unconstitutional, parts of laws, because they don't pass text, history, and tradition. They were made up over the last couple decades by anti-gunners. And we've had a very positive movement since that Bruen decision in the courts. Well, one Obama-appointed judge just turned his nose up at it, and the way he's doing it could prove dangerous going forward. What do I mean? Well, I'm going to read you this 6-page order by Judge Carlton Reeves, who is, like I said, he was appointed by President Obama. He's a federal district court judge in the Southern District of Mississippi. And what he has done here is to basically scoff at Clarence Thomas saying that judges should make their decision based off of the history and tradition around 1791. Because this judge is saying, hey, as good as they are in the Supreme Court, they're not historians, and neither am I, and maybe I should just appoint historians to help us with this. Now, that could be dangerous because there's a lot of historians, a lot of them, who are not pro-Second Amendment. They say that the Second Amendment was bastardized, and it's the NRA's fault that people can carry guns, and it hasn't been an individual's right since Heller, and it was never that before, and it's insane. But I want you to read this with me. I want to show you this order by the judge because this could be dangerous going forward. And this is in the case of a felon who is prohibited federally from owning a firearm. He's challenging that, saying that the text, history, and tradition didn't stop felons from carrying just based off of that title of felon alone. So here's the order. And this is in the case of the United States of America versus Jesse Bullock, a.k.a. Boomin' Bullock. It says, before Carlton W. Reeves, the district judge, the issue in this case is whether the federal statute prohibiting felons from possessing firearms, 18 U.S.C. 922 G1, is unconstitutional. The battle lines are clearly drawn. Jesse Bullock argues that the statute cannot withstand the Supreme Court's latest decision interpreting the Second Amendment. See New York State Rifle and Pistol Association versus Bruen. Founding-era legislatures did not strip felons of the right to bear arms simply because of their status as felons, he writes. The government disagrees. Its 4-page brief limits Bruen to its facts, arguing that the Supreme Court's new decision says nothing about the statute at issue in this case. The government then summarily asserts that 922 G1 is part of the historical tradition of regulating firearms possession. As courts have realized after Bruen, adjudicating the issue presents certain difficulties. Bruen instructs courts to undertake a comprehensive review of history to determine if Second Amendment restrictions are consistent with the nation's historical tradition of firearm regulation. In fact, Justice Alito commends the majority for its exhaustive historical survey. But historical consensus on this issue is elusive. As the Seventh Circuit put it, scholars continue to debate the evidence of historical precedent for prohibiting criminals from carrying arms, in which they mention scholars disagree about the extent to which felons, let alone misdemeanants, were considered excluded from the right to bear arms during the founding era. The Bruen court acknowledged that historical analysis can be difficult. It sometimes requires resolving threshold questions and making nuanced judgments about which evidence to consult and how to interpret it. That is an understatement. This court is not a trained historian. The justices of the Supreme Court, distinguished as they may be, are not trained historians. We lack both the methodological and substantive knowledge that historians possess. The sifting of evidence that judges perform is different than the sifting of sources and methodologies that historians perform. Courts are, after all, staffed by lawyers, not historians. And we are not experts in what white, wealthy, and male property owners thought about firearms regulation in 1791. Yet we are now expected to play historian in the name of constitutional adjudication. In reviewing the briefing and authorities presented in this case, and after conducting its own research, this court discovered a serious disconnect between the legal and historical communities. Simply put, the firearms history that appears in law journals and court briefs is not the same firearms history familiar to many mainstream historians. A right to bear arms, the contested role of history in contemporary debates on the Second Amendment, and that 187 Jennifer Tucker et al. Perhaps the most glaring disagreement is whether the Second Amendment confers a broad individual right to bear arms or a more limited collective right to bear arms. The Supreme Court decided in 2008 that the individual right was more faithful to the Constitution. There seems to us no doubt that the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms, the court held in Heller. Historians have now weighed in. They call this the standard model. Yet, an overwhelming majority of historians remain unconvinced by the standard model's interpretation of the Second Amendment. The fact remains that since the arrival of the standard model Second Amendment in the 1970s, its scholars broke and continue to break virtually every norm of historical objectivity and methodology accepted within academia. Minority viewpoints are cast as majority viewpoints. Historical speakers and writers' words are cast in terms outside the bounds of their intended context or audience. The intellectual and political thoughts of different historical eras are explained from modern vantage point. Historical presumptions or inferences are sold as historical facts. Even worse was the standard model scholars often built one unproved historical presumption or inference on another and another. And in many cases, standard model scholars fail to adhere to even the most basic norms of historical objectivity and methodology, such as conducting comprehensive research on each person, topic, or event, and reading and incorporating the seminal accepted works on the subject, or at least distinguishing one's conclusions from said works. This echoes other critiques. A common theme emerging from that literature is historians' frequent complaint that lawyers just can't seem to get it right. The problem has gotten more attention since Bruen. Historians have been unsparing in their criticism of the decision. One expert on the Second Amendment called the court's historical analysis an ideological fantasy. Another historian noted the growing number of strictures on what the court counts as historical evidence. There is no method to it, nothing but inconsistency and caprice. These critiques support an increasingly common attack that the court simply cherry-picked the historical record to arrive at its ideologically preferred outcome. Not wanting to itself cherry-pick the history, the court now asks the parties whether it should appoint a historian to serve as a consulting expert in this matter. This court is acquainted with the historical record only as it is filtered through decisions of the Supreme Court and the Court of Appeals. An expert may help the court identify and sift through authoritative sources on founding-era firearms restrictions. Within 30 days, the parties shall respond and indicate their position on the appointment of a consulting expert. So ordered this 27th day of October 2022, Judge Carlton W. Reeves. Now, this judge is kind of going outside of what is supposed to be done. The Supreme Court is the supreme law of the land. Their judgments, their rulings are binding, and the lower courts shall follow them. They don't get to go off and say, there's a bunch of historians here that don't think guns are cool, and the Second Amendment didn't mean that. And I think that too, because I'm an Obama appointee, and Obama wouldn't have appointed me to the bench if I was pro-gun. So I want to try to bring those resources in to cast doubt upon the Bruen decision. It's a game. It's a political game. He's doing this politically because the things they complained about, how minority decisions or minority viewpoints are being cast as majority viewpoints, they don't seem to have a problem with it if they look around today, right? Look at the big push people identifying as, stalks of bamboo. That's okay. Well, that's definitely a minority viewpoint being cast as a majority viewpoint, and you must accept that. So they're playing both sides of the coin here, and I hope that this doesn't. I hope that this doesn't end up being something more damaging. But I really think that the opportunity is there. So we'll see how this court proceeds. Let me know what you think down below. I will keep an eye on this. If you want to stay in the know, subscribe to the channel down below. I would love to keep pushing this this information out. And in order to help me do that, I need you to do a couple things to support the channel. First off, subscribe to the channel down below. Hit the button. It takes 2 seconds to do that. Right next to that is the thumbs button. The thumb button. Click that to like the video. Lets YouTube and the algorithm know that people want to see this, and it helps to push it out because they have been stomping on this channel and others for a couple weeks now. Also, share the video on different platforms. Share it with friends. Share it on your social media. It would really help get the word out. And of course, make a comment down below. Let me know what you think about this judge kind of bastardizing Clarence Thomas's written decision on the New York State Rifle and Pistol Association versus Bruen, which is the supreme law of the land. It's amazing the reaches they'll go, the depths that they'll go to try to obtain their agenda goals. Guys and gals, until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. That's what it's for. Doesn't matter what this liberal judge thinks. Doesn't matter what Obama thinks. All that matters is what the Constitution says. Take care.